husband and father, and we're here today, this afternoon, to do a little lunch and learn. We've gotten a number of questions over the years from our clients about what is the role of my successor trustee and what can they expect. And as we go through working up the designs for clients, and we're working through building up their trusts and going through the different options available, invariably it comes back to, well, what can our trustees expect? So we put together a little lunch and learn today, just to kind of talk briefly about some of the roles and responsibilities of successor trustees, in the hopes to better inform you about what things that you should be thinking about when you're selecting your trustees, or if you are a successor trustee for somebody else's trust, that you know what to expect coming up in the future. So we're going to get started in just a minute, and as we have people coming in, we asked that you put your questions, just a little bit of housekeeping to start. We asked that you put your questions in the chat. I have my awesome assistant, Laura Bisignano, who's going to be monitoring the chat and letting me know what questions there will be there. So I will answer them as we go forward. We will have a Q&A period of time at the end of our lunch and learn today. So feel free to stick around afterwards, as well as have an opportunity to learn about something special. So be sure to stay to the end so you can learn about that and ask your questions as you go. And Laura will moderate. And if anything, we'll get to your questions at least by the end of the presentation today. And of course, we will get you out on time, as we value your time and want you to be able to enjoy the rest of your day with this full knowledge ahead. So without further ado, coming through, we'll let others catch up as we go forward. And thank you for all those who have attended the webinar today, and some of you have attended others that we've had in the past, I see. So thank you for coming back to learn some more. As my mom always said, knowledge is power, and we can't make good choices without being fully informed. So today, let's talk about what we're going to be informed about in regards to successor trustees. But first, in case you don't know me, and if you aren't a current client or a trustee of a client, my name is Kevin Snyder, Snyder Law, and it's all about family for me. Here is my family, my lovely wife, Carolyn, who many of you know work here, our kids, and our respective parents. And that's what it's all about. And this is why we do what we do, in order to help families like ours, just like yours, so that we can walk forward on the road of life together in a way that we can support you, because we've seen it and experienced it with our own family. So what are you going to learn today? I thought it'd be helpful to just do a really quick snippet on a review of what a living trust is and how it works. Don't want to assume anything for those of you that are new to our lunch and learns. It's also just a great little quick reminder and primer for those of you clients of ours or others that have a trust, are well aware, because it impacts who the successor trustees are. And we're going to talk about the role of a successor trustee. We're going to talk about, you're going to learn what is on the to-do list for the successor trustee, and conversely, what's on the not to-do list, just as important. And we'll talk about our trustee handbook that we provide in our firm. So those are the things that you're going to learn today. Like I said, ask questions as you have them, and we'll moderate as we go through. So let's review. What is a living trust? A living trust is a revocable living trust, are all the same things. This is what we're talking about today because many of you have revocable living trusts. However, the role of a trustee also is part of any trust, really. So the things that we talk about today are also applicable to any other types of trusts, whether they're revocable or irrevocable. But you're starting out with the planning with likely a revocable living trust. And that is a legal document that a person creates, like you, and it's designed to hold and manage your assets during your lifetime and set a plan and a roadmap for what happens to those assets after you've passed away. And that plan is implemented during life by you as a trustee or your successor trustees if you become incapacitated, and is implemented in your death by your successor trustees. So if the plan that you want move forward and the outcomes that you want to happen is going to happen, then it's really critical that we have an understanding of what the successor trustee's role is, and we've chosen the right people for the job. Because again, here you are, you've created the living trust, you've moved assets into your living trust. So now when your trust goes into effect, either from your incapacity or your death, now we want your trustees to be able to manage what's inside that trust. You can do that now, but your successor trustees will have that opportunity later. And a big difference is, just as a side note, between the two of you, is between you and your successor trustees, is you as the trustee have the ability to make changes to your trust. However, when there is a life event like an incapacity, or there's a life event like a death, now your trust becomes irrevocable. Your successor trustees take over, but unless they're your spouse that you've created your trust with in a joint trust, your successor trustees will not be able to make changes to your trust by themselves without having to seek court orders or other actions. Your trust becomes not changeable, irrevocable. So their job is to carry forward the plan that you've left in place in accordance with the California law or the state in which the trust was created and is being implemented or administered. And I say implemented, legal term is administered. So where the trust is being administered. So like I mentioned, during your lifetime, it's business as usual because it's your trust, you're the trustees, you're in control. But it's acting as a standby or when you're no longer in control. And when those times are that you're no longer in control, generally we have a crisis or emergency. And that is if there's a health event and you're temporarily unavailable to be able to manage your trust, maybe something more permanent like a diagnosis of dementia. You've lost the ability to have cognitive functioning for a long period of time permanently. Or it's if there's been a life event and you've passed away. Those are all times when your successor trustees would take over. In addition, if you resigned as a trustee, your successor trustee would take over. So it's either incapacity, death, or resignation is when your successor trustees now have the authority to act. I want to take a little side note to point out the importance of, in your planning, to be able to really set forth the standards and requirements of when successor trustees are going to take over and have the authority to act, because it is going to create potential challenging situations if it's not thought about in a thoughtful way, or it could be a very seamless process. For example, what sort of requirements are we going to establish that show that you are incapacitated? Are we going to have a complicated rubric of standards that your successor trustees will have to pass through in order before they can be legally deemed to have authority to act on your behalf? In other words, are we going to have a panel of 3 or 5 doctors having to evaluate you? Or are we going to have something a little bit more streamlined, like an attending physician having to evaluate you to determine your incapacity? It's important to take a look at what those conditions are in your trust, because you want your successor trustee to be able to step in and help and have the authority to act when they need to. So when they do come in and step in to have the authority to act in the role of successor trustee, the ideas are coming to your rescue. That's why we want them to have the ability to act as quickly as possible. In order to and not have a tremendous amount of work or paperwork to have to establish that they have the legal authority to act. So let's just assume that we have done that. Our successor trustee can come to our rescue and step into the role. There are two really important periods of time when that's going to occur. Again, when you're alive and you're incapacitated, or you have passed away. The role of the successor trustee is similar in both of these situations, with some little nuanced differences that we'll talk about. It's similar in the fact that your successor trustee is the ultimate gatekeeper for you and the assets in your trust. So as the gatekeeper, their whole role is to manage the assets in it. We'll get the slide fixed here, getting a little ahead of ourselves. The whole role and purpose is to manage the trust assets in your trust. If you're incapacitated during your life, after you've passed away, we're going to protect beneficiaries from themselves or others after you've died. But in order for this to work, you, as we were mentioning, we have to have the right provisions set up in your trust, and you have to have the right people for the role. So the right provisions, one we were just talking about, how do successor trustees, when do they step into their role? So we want to have up-to-date provisions that you're comfortable with, that you've been able to play out and see how they work in real time by doing some fire drills and stress testing it. So, okay, we know when the successor trustee is going to come in and what they're going to need to do, what doctors they may need to hire and retain for an evaluation, or if there's other standards that you've chosen, how that all plays out. Also, what are they going to be able to do as the trustee? What are their powers? And the successor trustee powers, a lot of them rest within the conditions of the trust. The ability and power to sell and buy property, to have access to bank accounts, to have management of any businesses that you may be a shareholder of or be a member of if it's an LLC, a power to trade stock, for example, the power to manage and have access to digital assets, which is a more new development over the last decade of having that individualized power as we have acquired and developed new and different assets that are of a digital nature, whether it's data, whether it's photos, whether it's files on a computer, or we now have new things like Bitcoin and NFTs. And so we need to be thinking about our successor trustees' ability to have power and management over these different types of assets and what they're allowed to do with them. We also, so looking at your provisions of your trust and making sure that they're updated will be helpful. Now, in addition to what the provisions of your trust say, there's also a host of laws in California that also dictate the fiduciary duty of a successor trustee, what they are required to do in addition to what the trust says. So the trust is not the end-all be-all. It provides a lot of powers, but it is also existing with the overlay of the California law and the probate code that dictate what the roles and responsibilities of the successor trustees are as well. And of course, you must have the right people for the role. And this is a lot of what we have conversations about with our clients. So what are the characteristics of a successor trustee? And knowing what the job that they're going to have to do is going to be helpful for you in assessing that on an individualized basis. But at a basic level, you want somebody that's going to be responsible, somebody that is going to be accessible, somebody that has the capability and capacity in their life. As an example, if they have a busy young family or a busy career, they might not have the capacity in which to have the time to devote to all of the responsibilities of a trustee. So those are things to consider, along with other items such as geography. We have to consider citizenship as well, because we need to have a U.S. citizen to serve as a trustee. So those are all, of course, considerations when we're looking at individual people. And you can also consider people outside of your circle of family and friends or trusted advisors to be trustees. You can look at other neutral individuals, such as professional fiduciaries, whether those are individual professional fiduciaries or they're corporate fiduciaries. Corporate fiduciaries are banks that have trustee services, and those sometimes are good options when you don't have a lot of trusted family or friends to serve in that role, or you don't have people in your life that hit the hallmarks, whether you trust them, but they're not going to be good candidates for other reasons. Then looking at a professional fiduciary or corporate fiduciary is a great option to have the right people in the role because they're certified, they have more bandwidth and experience. So moving forward, looking at the general duties of successor trustees. So remember I said that looking at the trust, your trust documents themselves and how we develop the powers are going to be very, very important and instructive of what the successor trustee is going to be able to do. For, like, as an example, can they rent out a parcel of property? Can they create a business entity? Can they sell a home? Can they encumber a home, get a loan on the home? Those are all the powers. But there are general duties that the California law attributes to successor trustees, and they fall into three main categories. When a successor trustee comes into power and they now take over their authority as a successor trustee, that's when these three categories come into play. And if we have somebody who passes away. So if we have the grantor, the people that created the trust, if it's a joint trust, both of the spouses pass away, or if it's an individual trust, the one person who created the trust passes away, there are no other grantors to the trust. Now we have the successor trustee coming into their authority, and these are the three general duties that they're going to have. They're going to need to work immediately to collect, evaluate, and manage assets. They're going to have to start getting control of the assets in the trust. In order to do that, they're going to have to assert their authority as the trustee in a specific legal fashion to now announce to the world that they are the successor trustee in charge of this particular trust. So I'm the successor trustee of the ABC Family Trust. And so that financial institutions will recognize, other government agencies will recognize them as having the authority. Part of that is also establishing a trust identification number, because a revocable trust was connected to the grantor's social security number as the trust identification number. And now the new trust moving forward, now that it's irrevocable, is going to need its own trust identification number. So you're going to have to, the trustee is going to have to now use its authority to establish with the IRS that they're managing this particular trust, and this is now, and requesting an identification number for it. And that will allow the trustee to start collecting and ensuring that the assets are in the trust. So they're going to have to go around and do a search and make sure that they understand what is in the trust itself. What accounts have you put in the trust? What real estate have you put in the trust? What other life insurance policies, or what other qualified or non-qualified retirement accounts perhaps have you designated as the trust as a beneficiary, or other accounts that you've designated the trust as a beneficiary? Are there other assets in the estate that should be in the trust that didn't get into the trust while the grantor was alive? So your trustee is going to have the responsibility of doing an inventory of everything. And that includes an inventory of personal belongings before any of that is given away or there's an estate sale. So they got to get command over everything initially. And then they're going to have the responsibility, if they're managing assets moving forward, which they could for a long period of time or a short period of time. If this is a trust that's set up after death to be a very straightforward administration. As an example, the husband and wife both passed away, and they have 3 children, and they want everything divided equally and given outright to them in equal amounts. That's a fairly straightforward trust administration from a standpoint of what should happen. However, the trustee is going to have to make sure during the time in which they are acting as their authority before any inheritance is finally given out, that they're managing the assets correctly. So they're going to have the duty to manage assets as a prudent investor, meaning that they need to do so in a prudent and wise way. And they're going to be required to get advice and hire professionals to give them that advice if they don't already have that experience on their own. So as an example, as a prudent investor, taking trust assets and purchasing the newest IPO in the stock market isn't going to be a prudent thing, as well as just leaving it in a savings account with practically no interest as well might not necessarily be deemed prudent. The trustee also has the responsibility to make productive use of assets. So if you have real estate, for example, might need repair in order to be rented for a period of time to generate income for the trust, it's going to be up to the trustee to ensure that that happens. Basically, if we think about it, the successor trustee becomes the general contractor for the entire trust. How long they're the general contractor depends on how long the trust administration is going to last. In addition to getting command over the assets, managing the assets is going to be the responsibility for the trustee to pay debts, which are going to be any expenses that the grantor you had during your lifetime, and any taxes that you owe as well, or any taxes that your estate owes if there is an estate tax. Or if there is a sale of real estate during the trust administration, there might be a capital gains tax as an example of a tax. So it's going to be the responsibility of your trustee to research and look and determine what expenses are out there. Did you have any other creditors that were out there, all before they're able to make any distributions? Because if they make distributions before that's determined and a creditor comes out of the woodwork later with an established claim, and the trust has already been distributed, then that's going to pose problems for the successor trustee to have, that they might have some liability for that if they weren't acting in a way in which to show their due diligence, that they were seeking out potential creditors and paying off expenses. As a little side note, on this, when it comes to credit card debt, a little helpful hint, credit card debt of a person who's passed away is an expense, right? That still is going to belong to the estate or the trust. One thing that successor trustees can do is when they're contacting the credit card company, they're going to end up talking to their estate department. And there are sometimes some possibilities in order to pay off a lower amount of the actual debt on the card. So in lieu of simply just paying off the card right away, you want to talk to the State Department of the credit card when you're informing them that the individual has passed away. And part of paying off debts and expenses is doing just that, is informing the world that the trustee has, the original trustee, the grantor, has passed away. Have to make sure that Social Security is contacted, any other state agencies. For example, if the person who passed away was receiving any sort of disability benefits from a state or federal agency, maybe like they're receiving Medi-Cal benefits, but you need to contact these agencies. Contact the credit bureaus and let them know that the people have passed away. all this information is going to be a requirement of a successor trustee. So if we have collection, evaluation, and management of assets, payment of debts, we need to get then the third category of a successor trustee's responsibility when somebody's passed away is distributions to beneficiaries. And it seems so easy, 1, 2, 3. But these are very concerted steps. In order for distributions to beneficiaries, according to the terms of the trust, for that to happen, the successor trustee is going to have to look at the types of assets that there are. They're not all going to be in liquid cash form. Some are going to be in real estate. Some might be shares of a corporation or a business. And the trustee is going to have to get valuations of all those assets at the time of death in order to determine what the value of the trust was in order to achieve the distributions that the trust was stating. If, for example, the trust says, I want my child to receive 20%. Well, what does 20% of the estate look like? How are you going to get to that 20% in regards to the types of assets there are? That's all the job of the trustee to determine. And in addition, managing out some of the tax burdens that go along with that is going to be part of the responsibility of the trustee. Thirdly, distributions to beneficiaries may involve personal belongings, and the trustee is going to be responsible for those distributions unless, according to the terms of the trust. And sometimes the trust isn't so clear as to what those distributions are going to be. They're more general, but it's going to be the trustee's job to ensure that those personal belongings are distributed in the manner that the trust states, in a way in which to avoid conflict and in order to have a seamless transition. So this successor trustee has a full-time job, rightfully so, as they go forward in time from the beginning of collecting, evaluating, and starting to manage assets, trying to research all the different debts and expenses, from debts that already existed to funeral expenses to potential estate tax moving forward, and determining the distribution plan under the terms of the trust based on the value and the types of assets that are in the trust. And lastly, actually making those distributions in a fairly reasonable timeline. They have to do that. This can't go on for years and years and years. The beneficiaries have certain rights that we'll talk about in a moment, and make those distributions timely. And then lastly, making sure that all of the taxes are paid accordingly and the tax returns are filed. The person who passed away is going to have their personal tax return, and the trust is going to have tax returns that they're going to have to file on an annual basis, on an ongoing basis, I should say, if the trust remains open for as long as the trust remains open. So there are going to be responsibilities to that the trustee has to ensure that all the right tax filings are being made, and any notices that need to be provided to beneficiaries are being provided. Those notices include at the very beginning, within 60 days of the death of the grantor, there needs to be notification that goes out to the beneficiaries and potential heirs of the person who passed away. Then there's notices about distributions. There's notices about income that the trust receives. The successor trustee has responsibility of making sure that all these legal notices are received in a timely fashion. If not, then they're subjecting themselves to potential liability for any damages that might result. So even though it says 1, 2, 3 here, make no mistake, there's a lot of detail, a lot of meat that goes on in between the lines. And at the end of the day, if the successor trustee isn't capable of doing it all on their own, which they're not going to be necessarily, they're going to have the responsibility and fiduciary requirement of hiring professionals, whether that's a financial advisor, CPA, an estate attorney, to assist them. And lastly, if they're still not able on their own to fulfill their role because a lack of capacity or a lack of an ability in their life, they have other things going on, then they have the responsibility to step down and resign. Or if they become incapacitated or passed away, of course, then the succession moves on to your next successor trustee in line. So let's take a shift here and talk about on the other side, some important things to know about the beneficiaries and what rights they have, because it is tied to the responsibilities of your successor trustees. Because when you have your trust implemented, you're going to have trustees and you have beneficiaries. Sometimes they're going to be a mix of the same people, sometimes not. But a beneficiary has these following rights. They have a right to be notified over major events of the trust, like when there is the person who created the trust passes away. So we just talked about certain notices go out. If there are any court filings, if there are any subsequent changes in successor trustees, they have a right to get notified about that. Information regarding the inventory of trust assets. What was there in the trust? They have a right to have a copy of the trust. They have a right to request an accounting, unless, of course, they waive it, and they have a right to have timely distributions. So because the beneficiaries have all these rights, you can see conversely, the successor trustee has all the responsibility to make sure that these things happen and make sure that they're fulfilling the legal requests and rights that the beneficiary has, because if they don't, then they're going to walk into some estate litigation, which nobody wants on either side. For that reason, we move to the successor trustee to-do list. What should we look at all these responsibilities that I've talked about and the roles of the successor trustee moving forward and implementing your trust. Here are some things that we want to just highlight and recap again what's on the to-do list. So the very first thing that a successor trustee needs to do is establish their authority as a trustee. So whether it's the question of you've become incapacitated, the grantor becomes incapacitated, what does your successor trustee have to do to assert their authority, and making sure they're doing so right away, so that they can acquire a new certificate or certification of trust that says they are now the trustee that can act, and they can be recognized by the rest of the world that they're a trustee. So that's the first thing that they need to do, and oftentimes always recommend that they work with a professional estate attorney to do this, so that there isn't any hiccups in setting this up or missteps, particularly if you're needing to reach out and get a trust identification number from an IRS. From the IRS. I can't tell you how many times we've seen some mistakes there that take a while to correct after the fact. The trustee, if needs to take command of assets right away, sometimes it literally means to lock up assets. We're talking about making sure that there aren't any people that are going to remove items from the decedent's home, or if there's a concern about other items going by the wayside or taken, or perhaps there's a storage unit, for example, and the items are going to be lost if it's not paid for. Making sure that you're taking command of all of the assets so that nothing is lost. If you are serving as a co-trustee, if you and another person, which is common in a lot of older trusts, where you have perhaps two siblings who have been designated by the parents to serve as co-trustees. There's some challenges, and that should not be a decision that is made lightly when you're designing your trust for a number of reasons. But if you are a co-trustee, then you need to establish a relationship with your co-trustee because the two of you will be needing to act together. You need to understand your role of how you're going to act. The trust is going to dictate that. Can you act independently? Do you have an independent authority to act? Or must you act always jointly together? Or do you have a hybrid where you have to act jointly and sign things jointly sometimes, but there are some occasions in which you can act independently? And what sort of jobs are you going to delegate? kind of avoid a situation where you have one trustee doing all the work and the other one not, because that can lead to some issues later on down the road when it comes to how people feel and how trustees are not satisfied that they're not delegating the work appropriately between the two of them. So we want to avoid any conflict. That's the same as dealing with beneficiaries. So successor trustees really want to resolve disputes as soon as possible, whether it's between a co-trustee or whether it's with beneficiaries. We want to snuff those disputes out as fast as possible by acting in a reasonable way, offering for voluntary mediation, coming to terms, but of course, in a way in which isn't going to violate your fiduciary duty or go against the terms of the trust. An important note here is that the terms of the trust are hard and fast for you, and for example, with types of distributions. As trustee simply is going to have to follow those, and we'll talk about that in the not to-do list in a moment, of how not to, when you're resolving disputes and you're trying to come to a negotiation, that you're being mindful that you're not negotiating yourself into something that it goes against what the trust term says. A successor trustee should get professional help from the very beginning so that they have those advisors there supporting them through the process. And you should outline what the trust says for you to do. And always, always, always keep good records. I can't tell this enough to trustees from the very beginning. Keep good bookkeeping and records, and you may need some assistance with this from a professional to do that. Keep receipts of everything that the trust is expensing out, or if you personally have expensed something out on your personal end and you want a reimbursement, making sure that you're keeping receipts and good bookkeeping, so that if you have to establish an accounting, then you have all the information at hand in order to do that, whether it's an informal accounting or a formal accounting. Informal accounting being one that the trustee, as agreed upon by the beneficiaries, can put together. A formal accounting is going to require a CPA with experience doing trust accounting to put it in the specific California format. But you're going to need that information there. So from the get-go, keep good accounting of both expenses, what's coming into the trust as income, inventory of the assets, and also time in which you are serving as a trustee. Here's some things not to do on the not to do successor trustee list. Engage in self-dealing. What does that mean? Meaning, well, I like some of the assets that are in the trust that I'm now serving as a trustee on, whether it's mom and dad's trust or it's somebody else's trust, and I want to personally loan the trust some money, or I want to purchase that asset outside of the trust. Even if it's at fair market value, all of that is engaging in self-dealing, which is something not to do. And oftentimes a good reason to have a neutral trustee in there, so to avoid the temptation for a non-neutral trustee, someone who we call an interested person, from engaging in self-dealing. Do not allow for a conflict of interest. So you might be a trustee that has a business that offers professional services, even if it's, let's say, a moving service, or you have an estate sale company, or a cleaning service. It could be something more directly related to trust administration, or it could be something that is more innocuous, like cleaning service. Don't use your own professional services if you're serving as a trustee. So basically, your job to the trustee is to act in the role of the trustee and provide services as a role of a trustee. Don't provide services to the trust beyond your role as the trustee. Use an outside service to do that. And a lot of times we have children serving as trustees, and there are, of course, also beneficiaries. which could create a conflict of interest in how decisions are made by the trustee. And as a trustee, you need to be careful in making sure that the decisions as the trustee that you're making over the management or investment of trust assets, the timing upon which distributions are being made, the divisions of the types of distributions that are being made, how, like I said, how are we going to get to that 20% distribution for a beneficiary if we have different splits? All of that, if you are both a trustee and a beneficiary, you need to be mindful that your decisions are not in favor as you personally as a beneficiary, but your decisions are being made as a neutral individual, and so not to create that conflict of interest. And lastly, here in this slide, taking unreasonable compensation. So successor trustees generally, unless the trust dictates otherwise, are allowed to have receive compensation for their time and services as a trustee, in addition to receiving reimbursements for any personal expenses that they expended on behalf of the trust. Making sure that you're not doing so unreasonably, because that will put you in the crosshairs of the state law guidelines, lead to frustration with beneficiaries, and because you're going to have to be transparent about all of that. So make sure that you get educated. That's when working with other professionals like an estate attorney will help identify to you what is reasonable. Also, reasonable fees for other professionals is going to be the successor trustee's job to vet other professional services that we keep saying that you should use, but you want to make sure that they're charging reasonable fees, because if you don't do your due diligence, then you're beholden to the beneficiaries of the trust on that fact too, and put yourselves in a crosshair of some litigation on their part if they felt that you're being neglectful or negligent in hiring services and just spending trust assets freely without checking into whether or not they were reasonable. Of course, also on the not to do list, keeping poor records. So the job is to keep good records. So if you're keeping poor records, they're not doing a good job as a trustee, because those records are going to support your decisions and actions that you take, and you're going to have to be able to provide potentially a periodic accounting and being transparent. So if you don't have good records, that's going to raise a question in the beneficiary's mind whether you're doing an actual good job, or and that you may be, or are you being negligent and spending or wasting their inheritance. Not communicating. Of course, this communication in general life is key. So not communicating with beneficiaries is going to create problems. Return questions promptly, and don't let disagreements go unresolved, because once beneficiaries start to lawyer up, then I can tell you everyone loses, because now the trust assets are going to be used by the successor trustee to defend the trust. Beneficiaries are going to pursue action, and at the end of the day, it just becomes an unfortunate drain and waste of those trust resources. And lastly, don't act independently of what the trust says. Don't say, oh, this is my interpretation. This is what I believe. There's something confusing in the trust. This is what I believe it says. And so you're going to want to get insight as to what that is from a professional. Sometimes you're going to have to go to court to get the court to make a ruling on some confusing aspect of the trust. And you can't simply modify the trust for your own reasons, even as I mentioned, that you can't come together with a negotiation with the beneficiaries. You want to make sure that your any modification is being done in accordance with the trust terms and the state laws, and which oftentimes in here in California would require a petition for modification with the court. Just don't do it all on your own. So we come to as we get towards the end of our lunch and learn here, we want to look at your trust. Is it going to be properly driven and serviced by your successor trustees? So, and looking at all the things that your successor trustees are going to be responsible to do in their role as a successor trustee, both from a standpoint of what the trust says and from a standpoint of what California law says, or what the state law says in your state, then you're going to want to make sure that you are choosing the right people, and also that your trust has the right updated language in it. So that you have the right people that are going to be implementing your trust, just like the right mechanic servicing your car, and you have the right trust moving forward to assist your trustee to drive home the outcomes that you want. And that will definitely ensure a more seamless process in the trust administration, and which is what you want when you're putting this trust together. You want it to act in a quicker fashion than having to go through probate court, and you want it to have the outcomes that you want. And a damaged trust isn't going to provide that outcome for you. So as I mentioned, we're going to close with some things our successor trustee handbook. These are things that we give out to that we've given out to our clients in the past. And here's just some of the 10 things of the handbook that are really important that we've highlighted here, things that we've talked about today. So as a successor trustee, it's important that you understand your role, keep accurate records, act in the best interest of the beneficiaries, communicate with the beneficiaries, follow the terms of the trust, manage the assets thoughtfully, but also legally under the prudent investor rule. And we didn't mention this so far, but that's why it's here in our handbook. The top 10 is keep the trust assets separate from yours. So you don't want to commingle or mix your bank accounts or with the trust asset bank accounts, deposit any checks that should go in a trust account into your personal accounts. You need to maintain confidentiality about aspects of the trust administration up until there are points in time that you need to give transparency to the beneficiaries. Know when to resign as a trustee, and of course, who to seek out for professional advice and ensuring that they are charging reasonably. These are just some of the most important 10 that we've pulled out of a much larger trustee handbook that we provide our clients, and we provide our successor trustee clients that we advise in trust administration. So this is how we can help just generally. And then the clients that we have, number one, of course, helping you create a trust that incorporates the best trustees for successor trustees for you and your family, and that they are empowered in the best way and your trust is updated with the right powers. But also to review a trust of your successor trustee. Make sure that you are administering the trust if you are currently doing that or need to do that because someone has passed away or might be incapacitated now, or your successor trustee and you just have a question about your particular role coming up and you happen to have a copy of the trust. Well, let's schedule a trust administration consultation. It can be reviewed by an attorney in our office, like myself, and we'll have a conversation so you can better understand your role and get a checklist of the things that you're going to need to know and expect or do if you're actually carrying out your role right now as a successor trustee. So we've come to our questions and our Q&A here today. And I'm happy to answer questions that we might have in our chat. And so we'll go to the chat and Laura can help me out. One question that we had come up is coming in right here. Yes, the recording is going to be available for viewing later. So you can watch this and deep dive into different areas if you like, not a problem. Another question that's coming in here is when is the best time to contact a professional for help if I am a successor trustee? Well, as we mentioned, if you're not currently serving as a successor trustee, but you have a copy of the trust in which you've been named as a successor trustee, by all means, we can do a review of that trust and provide you some insight about what that trust may be asking you to do in the future, so you just have a better sense of what that looks like. If you are serving as a successor trustee because someone has passed away now, or you believe them to be incapacitated, that's always suggest as quickly as possible to seek out the professional advice of an estate attorney to make sure that you're taking the right steps to assert your authority, as we mentioned. And you also want to get a accountant and the CPA on board as quickly as possible. Because there's going to be a number of items that those professionals will be able to assist you with throughout. What's the timeline to close a trust? Great question. So the timeline to close a trust is dependent upon a few different factors. Kind of on average, like an average trust, what we tell clients is you can expect 9 to 12 months to close out the trust from beginning to end. And the reason is because at the end, there's always tax returns that need to be filed, the final tax returns. And oftentimes the timing in which there's been a death, there's been a death, let's say 2023. Well, then the tax return, even if all distributions are made in 2023, tax return is going to be filed in 2024. So that's why we have that 9 to 12 month time period. However, some trusts are ongoing. If the person hasn't passed away and they're incapacitated, that can go on for a longer period of time. If it's a surviving spouse, that trust administration can go on for the life of that surviving spouse. If a beneficiary receives a trust as a part of inheritance, then that is an ongoing trust that will go on for the length of time that the trust says it should go on, whether it's a period of years or it's for the lifetime of that beneficiary. Other times it's a lot shorter when we have outright distributions. In my example, parents have 3 children and they want to divide everything equally and outright. Then after the death of both parents, that's when we can expect 9 to 12 months of administration period total. Doesn't mean that the inheritance is received at the end of the 12 months. But for the role of the successor trustee, they can expect to have a 9 to 12 month job to do before they can move away from that job and that job be done, being the successor trustee. So great question. So not seeing any other questions, I want to thank everybody for coming in for the Lunch and Learn. It's always a pleasure to be able to talk more about what we do here, how we advise clients in order to give you the information that you need in order to best move forward, making decisions. As I mentioned before, as my mom said, the best way, knowledge is power, and the best way to make a decision is make an informed one. If you'd like to contact us, if you have more questions, you are a successor trustee, as I mentioned, and want to schedule an appointment with us, here's how you reach us right here. It'll be a privilege to be able to have a conversation with you. And thank you again for your attention this afternoon, and hope you have a great one. Keep being amazing, everyone.